appeal, Ramadhar and others.
Mr. Maharaj, good afternoon.
Much obliged, my lords.
Can I just address Mr. Campbell and Mr. Gilkes?
Yes,
please sit down.
Yeah.
Mr. Campbell and Mr. Gilkes.
Yes, my lord.
Good morning.
Good morning. Good morning.
Obviously, Mr. Maharaj will be addressing us first. If at any stage you have any concern about not hearing what is said or not seeing him or whoever is speaking, put up your hand and we will attend to it. Equally, when you two are speaking, if we want to raise something with you or have some concern and want to ask you to pause your submissions, we will put up our hands and you will kindly stop speaking so that we can deal with what's on our mind. Is that convenient and is that clear?
Yes, indeed.
We must remember, Mr. Campbell, Mr. Gilkes, that actually you represent different respondents. And so is one of you going to do all the speaking, or are you going to divide the time that you've got, 1¼ hours, in some way between yourselves?
Well, I expect, my lords, that our interests are aligned. So I expect that I will do most of the talking on behalf of my two clients, the first and third respondents.
Yes.
And I expect I will cover what we have to say in relation to Mr.
And so, Mr. Campbell, you're both going to do a certain amount of making of submissions. Well, you've obviously got to divide your 1¼ hours between you.
We will.
You will.
Yes.
Before then, is there anything else that either of you would like to raise before we begin with Mr. Maharaj's submissions?
I do not believe so, my lords.
Good. Well, thank you very much, Mr. Gilkes. Mr. Campbell. Mr. Maharaj.
Much obliged, my lords. My lords and my ladies, I appear with Mr. Tom Poole, instructed by Mrs. B.D. Pittmans, for the appellant.
Mr. Maharaj, I'm quite clear that we've all got to remind ourselves to speak very clearly and firmly.
Yes, my lord.
And that will apply to me, my colleagues, and also, please, to you.
Much obliged, my lord.
Thank you.
Much obliged, my lord. Mr. Frederick Gilkes appears for the first and third respondents. Mr. Mervyn Campbell appears for the second respondent. Both are instructed by Ms. Sinclair Gibson. The appellant, my lords and my ladies, is asking the board to allow the appeal and to uphold the dissenting judgment given in the Court of Appeal by Justice of Appeal Musai, in which the board will find at pages 767 and 786 of the electronic bundle. The board has the agreed facts at pages 828 and 840 of the record, and the board also has the agreed issues at pages 840 to 841 of the record. The appeal arose out of a defamation action in which the respondents alleged that they were defamed in words spoken by the appellant in his capacity as the political leader of the party of which they were members.
Mr. Maharaj, you're obviously right to have prepared a full opening, but please proceed on the basis that we have been spending a lot of time this morning and yesterday reading the papers.
Okay.
And so the full opening that you've properly prepared may be able to be abridged.
Much obliged, my lord. My lord, the main issues, we submit the main issues in this appeal are the first three in the agreed issues set out at pages 840 to 841, referred to in the appellant's printed case as grounds 1, 2, and 3, respectively, at paragraphs 19 to 40. The three issues are: were the words spoken by the appellants defamatory of the respondents, and whether the Court of Appeal should have considered the defense of justification, and if so, is the defense of justification made out? Those are the three main issues in our respectful submission. An important issue which arises in this appeal is the failure of the High Court and the majority of the Court of Appeal to consider whether the words complained of were defamatory of the respondents, taking into consideration the political context in which the words were spoken. Justice of Appeal Musai, in his dissenting judgment in considering whether the words spoken were defamatory, took notice of the circumstances and political context in which the words were spoken. And I'll give your Lordship the reference, particulars 28 to 29 of his judgment. We submit, my lords and my ladies, that the words spoken by the appellant, given in their natural and ordinary meanings, were not defamatory of the respondents. We also submit that this is put beyond doubt when the words are considered in the political context in which they were spoken. In the cases referred to in our supplemental case, the courts have recognized the greater latitude which ought to be afforded to words spoken or published in relation to political matters. The limits of acceptable criticisms of persons expressing political views are wider. And I wouldn't take your Lordship's it because your Lordships would have read it. We submit that the cases referred to by the Board, which the Board invited the parties to consider, show that the courts recognize the importance of freedom of expression on matters of government and politics. We rely in particular on what was said by Justice Kirby in Roberts and Bass at paragraphs 171 and 172.
Mr. Maharaj, could you pause there so that I can check with Mr. Campbell and Mr. Gilkes that they do have that authority to hand?
Okay, my lord.
Mr. Campbell, Mr. Gilkes, do you have that authority to hand?
We do, my lord. Yes, my lord.
You do?
We do, yes.
Thank you very much.
Much obliged,
Yes.
The case in question deals with the expression of political views by the respondent on the leadership and future of the party, and the expressions of the appellant of his response to the public criticisms made by the respondents of him and the decision made by the party to investigate the matters in question. We submit that the functioning and operation of political parties are an essential institution to promote the principles of representative government. And the importance of freedom of communication on matters of government and politics was recognized by Mr. Justice Kirby in Roberts and Bass at paragraph 124. Unlike the Australian Constitution, my lords and my ladies, which does not contain an explicit guarantee of freedom of speech, the Constitution of Trinidad and Tobago expressly provides for the right to join political parties and express political views in Section 4E of the Constitution. I've made a copy if your lordships want to see that, my lord.
Perhaps we should. Thank you.
Yeah.
Again, did you notify your colleagues that you would be referring to this?
I am instructed that we did.
You did.
my lord.
Good. Thank you.
Section 4E, my lord.
Section 4?
4E.
4E. Yep. Thank you.
I take it that your lordships and my ladies have read it, my lord.
We've got that now.
Much, my lord.
Thank you.
We do not submit that Section 4E right is absolute, my lords and my ladies. We accept that it is for the courts to decide in a principled and rational way how the fundamental right and freedom listed in the Constitution are to be applied in practice. Yes. As confirmed by the board in the case of Pandey and Gordon, 2006, one appeal cases at page 427, the statement of this right as a separate right in the Constitution of Trinidad and Tobago underlines the special importance attached to it by those who framed the Constitution, and I refer to Lord Nichols at paragraphs 19 to 20. My Lord, Lordships want to...
Let's read those paragraphs to ourselves,
Yes,
Mr. Maharaj.
Yes, my Lord.
Sorry, which page in the book?
It's loose, I think, Lady Alton. It's just been handed to
Right.
us.
Thank you.
Paragraphs 19 and
19 and 20.
Very well, we'll read that to ourselves, Mr. Maharaj.
Much obliged, my Lord.
Give us a minute to do so.
Sure, so, my Lord.
I think we've done that now.
Much
Mr.
obliged.
Maharaj.
My Lord, we do not submit, as I said before, that the Section 4E right is absolute, and it's up to the courts to decide in a principled and rational way how the fundamental rights and freedoms listed in the Constitution are to be applied in practice. What we submit, however, my lords and my ladies, that the importance attached to the right to express political views underlies and strengthens our submission concerning the importance of taking into account the political context when determining the meaning of the words spoken by the appellant. And the fact that the Constitution guarantees the right to join political parties emphasizes the important point that political parties are an essential component of furthering the objective of representative government. We submit, my lords, that the effect of the judgment of the majority of the Court of Appeal is that the political leader of a party in the context of similar circumstances occurring in the future is likely to face the risk of defamation actions being filed against him or her. We submit this would have adverse effects on the operation of political parties and will deal a serious blow to the need for openness, transparency, and accountability of political parties to their members and to the public. And that is why we consider this case as very important, not only for the parties in question, but for the principle which is involved in it, my lord. We submit that the majority decision of the Court of Appeal would create a serious precedent for the countries of the Commonwealth. If I can go to the structure of my submission, my oral submission, my lord. My lord and my ladies, I propose to follow the structure of the appellant's printed case. And as your lordship would see, in the printed case, firstly, we would emphasize some points. I obviously would not deal with length because of the time. But firstly, we would emphasize some points arising from the facts relevant to the issues in the appeal. Secondly, we would explain why the appellant says that the judge and the majority of the Court of Appeal were wrong to find that the words complained of carry the defamatory meanings ascribed to them when given their natural and ordinary meaning. Thirdly, we would explain why the appellant says the judge and the majority of the Court of Appeal failed to properly take into account the political context in which the words were spoken. Fourthly, we would explain why the majority of the Court of Appeal were wrong not to consider the appellant's justification defense. Fifthly, we would address the board as to why we say justification is made out in the present case. And sixthly, we would address the remaining grounds, namely fair comment, qualified privilege, and reply to attack, if time permits. If not, we will rely on our written submissions to that effect.
We think that's very convenient, Mr. Maharaj.
Much obliged.
In particular, before you said that the case mainly turned on meaning and justification, that was the very preliminary view we had formed.
I'm much obliged.
And so if you don't reach fair comment, qualified privilege and reply to attack, so be it. We'll just take your case from the written case.
Well, my lord, I would not go there in any event, because I would ask your lordships to read a written submission.
Very well, thank you.
If it becomes necessary, and I would spend some time with that time on the dissenting judgment given by Justice.
Thank you very much.
Much obliged. My lord, the relevant facts are set out at paragraph 7 to 17 of the Statement of Facts and Issues, pages 829 to 834. And before developing the appellant's submissions, I want to emphasize 6 points arising from the facts that are relevant to the issues in this appeal. Firstly, my lord, at the time of the November 2013 meeting, the appellant was the COPS, when I say COPS, I mean the Congress of the People, political leader, and he was also a member of parliament, and he was also a minister of government. The first and second respondents were members of the National Executive Committee of the COP. The first respondent also held the position of Secretary of Education and Research. The third respondent was a member of the COP and also an officer of the COP. Secondly, my lords, in the run-up to the local government elections, which were held less than 3 weeks before the November meeting, the respondents had been trenchant critics of the appellant and his stewardship of the COP. This criticism was aired publicly, my lord. We set out the references to the evidence in this regard at paragraph 63 of our printed case. And you would see, if I may merely summarize very quickly, the first respondent admitted at trial that prior to November 2013, he held many press conferences to air his notice to quit motion, and that these amounted to public attacks upon the appellant and his leadership of the COP. That would be found at paragraph 63 of our printed case.
Of course, the notice to quit was only about COP removing itself from the coalition.
Yes, my lord. Yes.
Yes?
Yes. The
resurrection motion was directed towards your client.
Correct, my lord.
Yes, very well.
Yeah. The first respondent also accepted that he went public saying that the appellant should resign and that the COP should leave the government even before his notice to quit motion was addressed internally by the COP. And your lordship would find that at paragraph 63A of the printed case. The second respondent admitted that he had also launched public challenges to the appellant's leadership of the COP and aired his resurrection motion in public. That is at paragraph 63B of our printed case. He also accepted that his resurrection motion attracted a lot of public attention. That is at 63B also of the printed case. The third respondent stated that in her view, the appellant was guilty of a number of infractions against the COP's principles, and that she had been advocating, and I quote, very, very publicly, for the party to remove itself from the government. That is at paragraph 63C of the printed case. She stated that she felt an obligation to remove the appellant from the temptations that were presented to him in government, and that she felt it better to do it publicly than rather within the party, and that this would have caused embarrassment to the leadership of the COP. That is at paragraph 63 of the printed case. It was against this background, my lords and my ladies, that the first and second respondents tabled the two motions for discussion before the National Council. The first, a motion to quit, effectively challenged the allegiance, as your lordships have stated, of the COP with the UNC, and sought to have the COP withdraw from the coalition government and the appellant resign as leader of the party. The second, a resurrection motion, which called upon the appellant to account for his stewardship to the party. Fourthly, in October 2013, the St. Augustine executive unanimously agreed that a motion should be prepared and presented before the National Council to suspend them from the party pending an investigation in their conduct. As it turned out, they were only suspended from the offices they held in the party, not suspended from the party, my lord. Fifthly, on the 1st of October 2013, a letter, which is very important in this case, was purportedly signed by the respondents and sent to the PNM, which is a party and opposed to the COP and the UNC, with a CD containing the membership information of the COP. The letter alleged that certain candidates of the COPs were not lawfully entitled to run as COP candidates in the local government elections. And sixthly, at the November meeting, which was held after the local government elections, the respondents withdrew their motions. However, the motion calling for the respondents' immediate suspension was read out. The contents of the letter of the 1st of October 2013 were also read out. There then followed a televised press conference, and a transcript of what was said is at volume 2, pages 216 to 222. The relevant part of the appellant's speech is set out at paragraph 17 of our printed case, pages 849 to 850, and we draw attention to those parts that have been underlined for emphasis. So Lordship should have it at paragraph, Lordship and ladies will have it at paragraph 17.
Yes.
Yes, and your Lordship would see the parts underlined for emphasis.
We do.
Yes, my Lord. My Lord, I should mention something about adoption of what was said by the appellant before he spoke. There was some discussion in the lower courts whether the appellant should be taken to have adopted the words spoken before the other speakers spoke, before him, before they spoke. Well, I'm sorry, before he spoke, the other speakers who spoke before him. This was in the context of an argument advanced by the appellant that because he did not identify the respondents by name, his words could not be said to be defamatory of the respondents. Although this issue of identification was raised in our printed case, it is not being pursued, my Lord. Identification is not being pursued.
That's very realistic, Mr. Maharaj.
Much obliged, my Lord.
Yes.
In the circumstances, we submit that the question of adoption of the words spoken before the appellant spoke is not an issue for the board, and the focus should be on the actual words spoken by the appellant. This appears to be common ground, as the appellant's case before the board, as set out in our printed case, is presented solely on the basis of the actual words spoken by the appellant, and the respondents have not taken issue with it in the printed case. Insofar as necessary, we submit that Justice Corcoran's finding that the appellant adopted anyone else's statements is confined to a finding that he adopted Mrs. Bachan's statement, and for reference, see paragraph 30 of his judgment, which is at page 606. However, this finding in our respectful submission is perverse and lacks any reasoning. It amounts to no more than saying that the appellant should be taken to adopt Mrs. Bachan's statement simply because he spoke after she did. This is not supported by any legal principle. In any event, Justice Corcoran goes on to consider the words spoken by each defendant separately. The board does not derive any assistance, with the greatest respect to the majority of the decision of the Court of Appeal, who apparently confused the issue of adoption with that of identification, and also adoption of what was said in the 1st of October letter, see paragraphs 34 at page 759. This takes me straight to ground one of the appeal, my Lord.
Thank you.
Were the words spoken by the appellant defamatory of the respondent. In overview, we submit. We address ground one, which concerns the meaning of the allegedly defamatory words at paragraphs 19 to 30 of our printed case, and also in our supplemental case, pages 1657 to 1660. As we submit,
Yes.
at paragraph 23 of our printed case, the appellant's overarching submission is that Justice Kokoram was wrong to find that the words complained of carried the defamatory meanings he ascribed to them. We submit that the words spoken by the appellant, given their natural and ordinary meaning, were not defamatory of the respondents. Furthermore, we submit that Justice Kokoram and the majority of the Court of Appeal fell into error by not taking account sufficiently or at all that the words were spoken in the political context. We submit that the board is in as good a position as the first instance judge and the Court of Appeal to determine the meaning of the words complained of. We submit that Justice of Appeal Musai struck the correct balance and was clearly right to find that the words complained of were not defamatory of the respondents when viewed in their proper context.
Is there any authority, either in the jurisprudence of Trinidad and Tobago or in that of England and Wales, about the approach of an appellate court to a finding of meaning by the trial judge?
My Lord,
you have said we're in as good a position as Kokoram J was.
Yes, my Lord.
That would almost suggest that you are submitting that we should decide it for ourselves.
Yeah.
But I wondered whether that was the law, either in the islands or in England.
Yes, my Lord, I anticipated that question. My Lord, the question of when it is appropriate for an appellate court to substitute its view for that of a trial judge on the meaning of a claim defamatory statement was addressed by Lord Kerr in the case of Stocker and Stocker. That is at tab 20, paragraphs 52 to 60, at pages 1543 to 1546 of the electronic bundle.
Thank you.
My Lord, at paragraph 59, Lord Kerr stated that he preferred to describe the appellate task as one of a discipline restraint.
I think we ought just to look at that.
Yes, my Lord.
If that's recent authority from Lord Kerr,
yes, my Lord,
it's likely to be well worth looking at. 59, did you say?
Yes, my Lord.
Yes,
paragraph 59.
It's tab 20 in volume 2, isn't it?
Yes, my Lord.
That's helpful, Mr. Maharaj. Thank you.
Yes, my Lord.
Yes, where were you?
Much obliged. We respectfully agree with Lord Kerr, and whilst we accept that the trial judge's conclusion on the meaning of the words spoken should not be lightly set aside, we submit that this is a paradigm case for the board's intervention. For the reason we have set out in our printed case, we submit the decision of both the High Court and the majority of the Court of Appeal were vitiated by errors of law, my Lord, and cannot stand. Put simply, we submit that the meaning that the trial judge has given to the words spoken were plainly outside the range of reasonably available alternatives. and that the trial judge did not give the words spoken their natural and ordinary meaning and failed to consider the words spoken in their political context. And with some time afterwards, I will go to the Australian case, my lord, because I think it's very helpful, my lord. So, my lord, if we go to the we submit that at paragraph 19 of our printed case, that the starting point is that the words complained of are to be given their natural and ordinary meaning.
Yes.
Guidance as to the court's general approach towards determining the meaning of a publication was provided in Jane's and News magazine, and I have it at tab 11, pages 1225. We set out the relevant passage from Sir Anthony Clark's judgment at paragraph 20 of our printed case. Citing what was said by Lord Kerr in Stocker and Stocker, we make the point at paragraph 22 of our printed case that context is a factor of considerable importance. This point is then developed in our supplemental printed case by reference to authorities. And you have our supplemental case, madam?
We do.
Right. And your lordship would have seen the authorities of Hector and the Attorney General of Antigua. That is at tab 3, which we rely on to make good our argument, the different consideration applied to words spoken in a political context. I propose to spend a few minutes developing this submission, given the importance of the appellant's arguments in support of ground 1, my lord. The starting point is a well-established principle that the courts afford greater latitude to criticism of politicians and public officials. And we say that this principle is in play here, given the positions held by the respondents and the political context in which the statements complained of were made. As we say in paragraph 3 of our printed supplemental case, the rationale for this more lenient approach was explained in Derbyshire, County Council and Times newspapers, where Lord Keith quoted from Lord Bridges' judgment in Hector and the Attorney General. A similar point was made by Justice Warby in Yeo Times versus Times newspapers, where he emphasized the importance of taking account of political context in which the statements complained of were made in determining whether they were defamatory. That is at tab 6 of the supplemental bundle, page 1733. The relevant passage is set out at paragraph 4 of our printed supplemental case.
Yes.
We also draw attention to what was said by Mr. Justice Beatson, as he then was in Calver, cited at paragraph 6 of our printed supplemental case, namely that enhanced protection was to be given to statements in the political sphere. A point that was echoed by the Court of Appeal in Watterson and Lloyd, tab 23, page 1593, by Lord Justice Laws, where he made a point at paragraph 67, page 1611, that a political context, especially at election time, informs the balance between free speech and private claims. So our submissions are, my lord, as we have already submitted, the appellant's overreaching submissions is that the words he spoke, given their natural and ordinary meaning, were not defamatory of the respondents. As set out at paragraphs 24 to 29 of our printed case, the appellant makes 4 points in support of this argument. 4 points. First, words were incapable of suggesting any findings against the respondents. Firstly, we say at paragraph 28 of our printed case, the words complained of are incapable of suggesting findings against the respondent. We say that the first instance judge was plainly wrong to find that the claimants were simply hung out to dry and tried in public even before they knew of the charges leveled against them. That's at paragraph 58 of the judgment of Justice Corcoran. If one looks at what the appellant said at the press conference, it can be seen that he was at pains not to impugn the guilt of the respondents. For example, he made the statement, "I make no pronouncements as to the letter's authenticity." He said, if it is true that they did these things, that is why there's suspension without a finding of guilt. And then he said, we'll all ask for a proper and full investigation to determine the facts in this matter. And if they prove true, the next step is for expulsion from the party. We respectfully submit that this was clear that the appellant never pronounced on the merits of the allegations against the respondent, such as to give actual substance to the allegations. Accordingly, the judge was wrong to find the words were defamatory. As we say at paragraph 27 of our printed case, such a finding required a great deal of interpolation, suspicion, and reading between the lines, whereas a straightforward, non-defamatory meaning ought to have been ascribed to the words spoken by the appellant. Secondly, the judge impermissibly had regard to the meaning the appellant intended. We submit that the judge fell into error by impermissibly having regard to the meaning he considered the appellant intended to convey. This can be seen at paragraph 57 of his judgment, where he states, the appellant's attempt to couch his speech in the terms of not adopting the truth of the letters was diluted by the force that he gave to the actual substance of the charges.
I think we ought just to look at that paragraph,
Yes,
Mr.
yes, my
Maharaj,
Lord. Yes, my
if
Lord.
it's convenient for you.
Yes, my Lord, paragraph 57 of the judgment.
Whilst we're looking,
It's at volume 2, page 617.
Thank you.
could I just check whether the reference in the paragraph above should be to paragraph 40, please? And there's another one of similar at paragraph 53.
What paragraphs are we looking at?
At paragraph 56 and
Of what?
53 of this judgment, just above
the
where
judgment.
just above where you've directed us to.
Sorry, my lady.
53 and 56.
Yes, it's
Lady Black is referring to paragraphs 53 and 56 of the trial judge's judgment.
52.
She's referring in particular to his reference to paragraph 41 above. And the question is whether that is a wrong reference on the part of the judge. Is that right?
yes.
Yes, my Lord.
I think
I think
Justice of Appeal Musai thought it was a wrong reference,
Yes, I think-
and that the reference should be to 45.
45, I think so, my Lord.
You agree with that?
Yes, my Lord.
Well, shall we proceed on that basis for
Fine.
the moment?
Yeah.
Yes, very well.
Much obliged. Have your lordships look at paragraph 57, my Lord?
57, very well.
Is attempt.
So how do you collect a reference to intention out of this, Mr. Maharaj?
Well, in what he's saying, his attempt to couch his speech in the terms of not accepting the truth of the letters was diluted by the force that he gave to the actual substance of the charges. Obviously, upset about the claimant's challenge, it was an opportunity to silence the destruction of even they were an ultimate finding.
If that's a reference to intention, it's a very, very oblique one, isn't it, Mr. Maharaj?
Would you give me a minute? Man?
Yes, of course.
My Lord, my submissions, the way I looked at it, is by using the word, his attempt to couch his speech in the terms.
Very well.
So
Yes,
he was
again.
trying to say that he was deliberately intending, but,
Yes, I see.
but in effect, he was camouflaging it.
Well, we'll consider that. Thank
Yes,
you.
Yes, my Lord. And it is in that context I referred to the case of Houghton and James, where we submitted at tab 9 at 1165 that one does not look at the intention.
Yes, well, that's
I'll leave
pretty
that.
basic law, isn't
Yes,
it?
yes, my lord.
Very well, yes.
Thirdly, and as already submitted, we say that the judge failed to take into account properly or at all the political context in which the words complained about were spoken. And had he done that, he should have held that the words in issue were not defamatory of the respondents. The board already have our submissions on that, and we say that when viewed in their proper political context, taking account the public positions held by the respondents and the nature and timing of the November 2013 meeting, the natural and ordinary meaning of the words spoken by the plaintiff, by the appellant, as set out in paragraph 25 of our printed case, namely that on production of the 1st of October letter, the National Council determined that an investigation was warranted. The respondent's response to the political context argument is set out at paragraph 42 of the printed case, but as we point out in our printed supplemental case, the respondent's reliance on Reynolds was misplaced because Lord Nichols in Reynolds was addressing the question of qualified privilege in that case. And as we said in 40, we are not pursuing the identification point, my lord. So the next submission is ground 2, and that is the Court of Appeal was wrong not to consider justification.
Yes.
My lord, we address ground 2, which concerns the appellant's justification defense at paragraphs 34 to 35 of our printed case. And that is at page 855. We submit that the majority of the Court of Appeal was wrong not to consider the defense of justification. This is because justification was an issue both in the High Court and in the Court of Appeal. We accept that justification was not expressly pleaded by the appellant in his amended defense. However, we submit that justification is implicit in the facts pleaded at paragraph 15 of the appellant's amended defense, which states the first defendant was not responsible for the publication of any material and or concerning the claimants that was untrue. And the amended defense is at volume 1, page 79.
Yes. Presumably, you rely to some extent on paragraph 26 of the trial judge's judgment, which we have at page 605.
Yes, my lord. At 26D.
Indeed.
Yes, my lord.
The main issues of law that arise for consideration are, D, whether the defamatory publication, singular, were true. I think an S must have been lopped off there.
Yes, ma'am.
And so doesn't appear to be confining the issue of truth to any one area of
Correct.
the case.
Correct,
he
ma'am.
appears to list it as a general point for him to consider.
Correct, my lord.
That's your submission, anyway.
Yes, my lord. And that's at volume 2, as you have it at page 605. And then he expanded on this at paragraph 32, where he spelled out the required elements of the defense of justification.
Yes.
And made it clear that this related to all defendants. That's at volume 2, page 607. And your lordships would have seen that at paragraph 56, the judge held that the words spoken by the appellant was commentary based on facts which were simply not true. So obviously he had in mind to determine whether it was justified or not. Volume 2, page 617. This, we submit, demonstrate that as far as the judge was concerned, justification was an issue for him to determine, and this extended to the words spoken by the appellant. In the Court of Appeal, although it was not raised as a discrete ground of appeal, we submit that it was clearly an issue in the Court of Appeal, as correctly observed by Justice of Appeal Musai at paragraph 20 of his dissenting judgment. And probably we can go to that, my lord. That's at volume 2 now, sir.
Yes? Paragraph 20, did you say?
Yes, my lord.
We've got that.
Your lordship will see wait.
It's at the foot of page
It is,
776.
It's the text
Yes, at
at
paragraph,
the foot of the page,
paragraph
776.
20, at paragraph 20 to the end of paragraph 20, and then he goes, submissions. Before embarking on the respective arguments, I note that before the judge, the defendants in their closing submission never pursued the question of meaning. However, it has now been made a live issue before this court without objection by the respondent, and as I indicated, the appellant relies on the defense of justification.
Yes?
Yes. At paragraph 21 of the dissenting judgment of Justice of Appeal Mosai, that is what I just referred. He said that justification was incorporated in the defense, the submissions filed by the respondents. 21. No, sorry. 733. I'm sorry. I'm sorry, my lord. Give me 1 minute, please.
Of course, Mr. Maharaj.
Paragraph 21 and paragraph 21 in the sentence. He said it was incorporated.
What are you looking for? Can we try and help you?
I think I referred to it, sorry. At paragraph 20, I referred to it. However, in his response, the submission of respondents filed on the 30th of October, it would appear that the appellant on the 10th of November incorporated defense of justification. That's in paragraph 20.
Of what?
Of Justice Musai's decision.
Right, yes.
I refer to that. I'm sorry.
Very well.
No, sorry. And then your lordship would see at paragraph 32 of the judgment of Justice of Appeal Musai, he refers to the thrust of the argument, which makes it clear that justification was dealt with in oral submissions before the Court of Appeal, and yet inexplicably not dealt with in the judgment of the majority. In the circumstances, we submit that the Court of Appeal erred by failing to consider, and I mean the majority decision of the Court of Appeal, whether the appellant could avail himself of the defense of justification, and for the reasons set out at paragraph 36 to 40 of our printed case, we submit, had they done that, they would have found the defense was made out. We submit that even if the appellant is wrong and the board considers that justification was not an issue before the lower court, the appellant should be permitted to advance an argument before the board that the words complained of were justified. And as your lordship and ladyship would see, as your lordships and ladyships would see at paragraph 31 of our printed case at page 854, the defense of justification is closely bound up with the determination of the meaning of publications, and we refer to Gatley at tab 26. As submitted when addressing ground 1, the board is in as good a position as the first instance judge and the Court of Appeal to determine the meaning of the words complained of and whether they were justified.
Can I just ask you about
Yes, my lord. My lady.
Your point that you've just made about the Court of Appeal, that they had not addressed justification, that the majority found a different meaning, didn't they? They affirmed the judge's meaning. Are you saying that justification was relevant even on that meaning?
Yes, my lady. Even if you take what the Court of Appeal has found, that justification was an issue And therefore, the majority of the Court of Appeal had to show that this was not a defense available to the appellant.
Well, if the meaning of what your client said was these claimants wrote the letter, that couldn't be justified, could it, Mr. Maharaj? Because it isn't established that they did.
Well, our first position is that that is a meaning was not open.
I know, but Lady Black asked you to switch
So
to
we are,
the other meaning.
yes, so we are contending that that was not a meaning open. But I'm saying...
We know you are.
Right, but assuming but not admitting that there could be such a meaning, assuming but not admitting there could not be such a meaning, it would seem that justification would not be
I think you must be right about that, Mr. Maharaj.
Yes, on reconsideration it would be so.
Yes.
Yes.
Thank you.
I'm much obliged, my lord. I'm much obliged.
Under this heading, is there anything really in issue other than meaning?
Yes.
Because if it meant what you say it meant, then it was true, there was an investigation, and if it meant more than that, then it wasn't.
Correct, my lord.
Yes. So it's really a meaning case.
It's a meaning. It's a meaning. It's a meaning. My lord, forgive me, I feel very strongly about the meaning of these words, and they were not defamatory. And even if you take it in the context of it, it's not defamatory at all. And in respect of ground 3, we dealt with the question of the appellant's justification defense. And if you'll permit me, I just want to make some points about it.
Of course.
Yes. We addressed ground 3, which concerned the merits of the appellant's justification defense at paragraph 36 to 40 of our printed case. As set out at paragraph 32 of our printed case, page 854, the respondents complained that the meaning of the words complained of is an allegation that they were involved to some degree in wrongdoing, and the court will determine the level of seriousness of the allegation by reference to 3 chase levels meaning. It is submitted that the present case is concerned with chase level 3, namely an allegation that there are grounds to investigate. I'm sure your lordships are familiar with that case.
We are.
And in the chase level case 3, the defendant must either show that an investigation is or has been conducted by the relevant authorities, or that there were reasonable grounds for such an investigation. We submit that the evidence clearly established a chase level 3 meaning that there were reasonable grounds to investigate whether the respondents were responsible for sending the 1st of October 2013 letter and disclosing the party's membership list. The appellant relies on matters set out at paragraph 36 of our printed case. Firstly, the letter was introduced at the National Council by a senior and prominent member of the COP, and the signatures on the letter appeared to be those of the respondent, a fact that they themselves acknowledged. Secondly, the letter referred to 3 candidates whose candidacies were alleged to be invalid. There was also a reference in the letter to an enclosed CD containing the party's membership list. Thirdly, at least one of the respondents had direct access to the party's membership list, which had been leaked to the PNM. The evidential basis for this statement is paragraph 15 of the appellant's witness statement, where the appellant states that further the first claimant, who was the party's secretary election and voter registration at the time, had access to the party's membership list. That is at volume 1, page 108. There is also a reference...
Volume 1, page?
Page 108.
108.
108, my
108, thank you. Yeah.
There is also a reference in the amended defense to the fact that at least one of the respondents had direct access to the party's membership list. See paragraph 21F, volume 1, page 81. Fourthly, the letter may have been the potential source of the PNM's complaint to the EBC. We submit
Did
that
the curious and late arrival of the letter before the council raise doubts reasonably raise doubts about it and its authorship, Mr. Maharaj?
Well, my lord, one could look at it in both ways, but in the politics of Trinidad and Tobago, this can occur. And therefore, I think that the party did the right thing to conduct an investigation, because your lordships and your ladyship ought to recognize that there was no charges leveled against them. It was an investigation. And as a result of the investigation, the charges were laid. So in a political party in Trinidad and Tobago, and I suppose in the Caribbean, it is very important for where there are these allegations for the public to know what is happening, so that confidence in the public, of the public in the party can be assessed. So a party faced with a situation where you have a member or an officer of the party possibly in league with colluding with the opposition party, well, the opposing party, in order to have a political score settled. That's a serious matter.
Of course.
In a very small society.
Of course it would have
Yes,
been.
yes. It's a very serious matter in a small society, my lord.
Yes.
So we submit it was against this background that the decision to pursue investigations are made, and there is no dispute that the matter was referred to the National Council, and after being voted on, to an investigative committee which subsequently conducted and concluded an investigation. Moreover, we have already said the appellant made it clear at the press conference that the authorship of the letter and disclosure of the attached membership slip was not being attributed to the respondents, nor was it suggested that it was their well-known stance and efforts against the leadership of the party which prompted the investigation. As held by Justice of Appeal Musai at paragraph 34, although some reference was made at the press conference to the conduct of the respondents, this was specific to issues directly related to an ongoing internal party situation that had by itself attracted significant public attention and continued to be aired in the public domain. If I may pause here a bit. My lord, it should be recognized that these were officers who publicly attacked the political leader. So at the press conference, in addition to reporting on what the party decided, it was not unreasonable of him as the political leader to deal with some of the responses, to make some responses to some of the accusations made of him. And that in those responses, there was nothing that he said that was libelous, but in any event, he made it clear that in relation to this letter, he was not making any judgment on the merits. In the circumstances, it is respectfully submitted that Justice of Appeal Musai was correct to find the defense of justification made out, and that is at paragraph 35 of his judgment. My lords, what I want to do, I want to leave fair comment, qualified privilege, and reply to attack, and rely on the written submissions. I want to spend the time I have to go through a bit with the dissenting judgment and go through the cases which the board has asked us to look at.
Very well, Mr. Maharaj.
If you'll permit me to do that.
Certainly.
Certainly. My lord, first, can I go to the dissenting judgment of Justice of Appeal Musai?
Yes.
Right.
$767. Yes.
Yes, it's volume 3.
Yes.
And if I can take your lordship to page 780, his analysis.
Yes.
And your lordship see at paragraph 28. His lordship said, I will take it that your lordship would have read this, but I just want to point out certain
Of course we have.
things. Yeah, yes. My lord, at paragraph 28, you would have seen that how his lordship dealt with the political context.
Yes, we have seen that.
Yes, and your
We
lordship...
will have either
yes.
mentally or actually
Yes.
ringed round the word political
Yes,
in
ma'am.
the fourth line.
Yes. And your lordship will see at paragraph 29, he dealt with how the both motions were withdrawn by the other side. And he talked about the CD, etc. And then you go to paragraph 30. In my view, the single meaning that the ordinary person would ascribe to the publication complained of is that on production of this letter purportedly signed by the respondents, the National Council, the highest functioning organ of the party, determined that an investigation was warranted. And then he mentioned what C. Prasad Bechan said. And then he said, the ordinary person, not avid for scandal nor unduly suspicion in considering the publication as a whole, would understand that Mrs. C. Prasad Bechan and Prakash Ramadhar were careful enough by the words of qualification used not to impute guilt to the respondent. Thus, in addition to her statement, etc., etc., and then he goes to paragraph 31.
Yes.
But before I go to paragraph 31, in the paragraph before, it naturally follows that I am of the view that the trial judge was wrong in finding that the words complained of carried the defamatory meanings that are outlined in paragraph 45 of his judgment. However, not much blame can be attributed to the judge, etc., etc. Paragraph 31. It would appear that the judge, in coming to the conclusion that he did, attached insufficient weight to the express qualification, and I leave that for your lordships and ladyships to read. Nonetheless, a finding that the sting of the publication is only that the circumstances warranted an investigation without a statement or implication that there was actual guilt or reasonable grounds to suspect it. Then your lordship would see at paragraph 32, when he dealt with justification, the thrust of the argument of Mr. Maraj SC is that an ordinary reason reader would not infer. So that, and he dealt with the issue of justification, and then at paragraph 35. In my respectful view, the appellant has established that the meaning of the publication, namely that there are circumstances warranting an investigation as to whether the respondents were responsible for the letter sent to the PNM and disclosure of the party's membership list, is substantially true and is therefore entitled to reply on the defense of justification. My Lord, with the greatest respect to the majority decision of the Court of Appeal, I think the Justice of Appeal Musai got it right, and I respectfully ask your lordships to hold that. My Lord, can I then go to a few of the cases that was referred to by the board? Because
Actually, after we asked you to look at those cases, we looked in more detail at your supplemental bundle, which is dealing really with the same point.
Much obliged.
And, you've already indicated that the judgment of Mr. Justice Kirby is you rely on,
Yes,
and we've got that, and we note the paragraph. Was there anything else in particular that added to your collection?
Yes, my Lord. I just wanted to direct your lordships to paragraph 64 of the judgment of Roberts and Bass. And I'm sure that your lordships may have looked at it, but just for emphasis, my Lord.
Thank you.
Paragraph 64.
Thank you.
Your lordships would see that it refers to enlarge the court unanimously held that freedom of communication on matters of government and politics is an indispensable incident of the system of representative government created by the Constitution. And then lower down in the paragraph, hence this litigation is concerned with matters at the heart of the constitutional freedom of communication respecting political or government matters. And then your lordship will see on the next page, it also requires that the rules of the common law conform with the Constitution for the common law in Australia cannot run counter to constitution imperatives. I quote this because, my Lord, it shows the importance of the existence of functioning political parties in the system of representative government. In other words, the principles of representative government can be a sham if you do not have political parties. And if you have political parties, it's important for there to be communications between the leadership and the governing organs to its members, to its officers. And there would be time when political parties and its governing organizations, in matters which has a public effect on the party, would have to make statements in public. And therefore, one can imagine that with a political party in a coalition in which the accusation is being made by senior officers of the party, saying that the party should remove from the coalition and that the party and the leader should resign, that it was of such a nature that a court should not be asked to determine whether statements made in that context, in the kind of statements which were made, were libelous or not, because there should be freedom of communication. That's the point I want to make.
Thank you.
And my Lord, if your Lordship also look at paragraph 169, and your Lordship, I ask your Lordship to note that passage, there. The common law doctrine as expounded in Australia must now be seen as imposing an unreasonable restraint on that freedom of communication, especially concerning government and political matters, which the common welfare and social function would be impaired. Yes. And the other passages relate to what your Lordships referred us to. Okay. My Lord, my learned junior reminded me that I should really ask your Lordship to look at the other two cases and point to the passages that I want your Lordship.
Very well.
The next one is the case of Sir Kenneth Barron and John Heath.
Thank you.
At paragraph 86, which the board, there's a very important passage there. And it says the primary focus of this jurisprudence, after it talks about the caution when limiting political, et cetera, the primary focus of this jurisprudence is on the need to avoid chilling legitimate political expression by ensuring that those who speak out in good faith on political topics are not unreasonably exposed to findings of liability for defamation. And then in the next...
These propositions most obviously relate to debate between political parties, but you say not limited to that.
No, my Lord.
This is an internal conflict within one party.
Yes.
Do these propositions relate to that?
My Lord, I would respectfully submit that they do relate to a situation in which a political party has officers who are making public statements to undermine and subvert the party, because in the system of representative government, you have to have political parties which are open and transparent and accountable to the public. And therefore, if you have statements which will undermine the party, then there should be freedom of communication between the leader, between its members, and in circumstances where the public reputation of the party can be adversely affected. There must be some freedom, otherwise people would always be afraid. If I put this in the context, assuming this judgment is correct and it's not interfered with by the board, assuming, what can happen in the Caribbean? What can happen in the Caribbean? You can have a political party, a leader, They can have similar circumstances, but that leader would be afraid to speak. So he'll be tongue-tied. So you'll have a situation in which you have an investigation ordered, you have a suspension, but the political leader would not be able to tell the party at a press conference or the public what the party is doing about the allegations. And that is why in political matters, there is a greater latitude, and I think the common law has developed in that respect. The cases which the board have referred to have endorsed that principle, in my respectful submission. But it also should be borne in mind that in Trinidad and Tobago, it's different to a lot of Caribbean countries and Commonwealth countries, because you have a specific guarantee of the right to join political parties and express political views. Although we borrowed that from the Canadian system, it was not in the Canadian Bill of Rights. So Trinidad and Tobago decided to have this freedom. And I think it is of great significance that the common law should be developed to be compatible with the fundamental right. Unless I could assist your lordship on the
Well, thank you very much indeed, Mr. Maharaj. Let's see whether there are any questions. Lady Arden's got one for you.
Would you like to take us to the exact content of the statement that was made and take us through it? It's very short,
yes,
but obviously what matters is its overall meaning, not
yes,
just...
I think the statement is reproduced.
Well, I was looking at it 1779, but it's probably better...
It's at paragraph 17 of the printed case.
In various places. The actual transcript is at 216, but where shall we
If your
best
lordship
look at it?
If your lordship look at paragraph 17 of the printed case of the appellant.
Very well.
And the bundle reference again is...
849. Sorry?
You want the reference is at...
No, I've got it now, thank
It's
you.
at page
Lord
849.
Paragraph 17, yes.
Yes, my lord. I can proceed, my lady?
Mm-hmm, please.
It says, contrary to many efforts by a few to destroy the party stood in its resolve that the party is greater than any individual or group of individuals. The party is the only hope in the politics of Trinidad and Tobago, and I say that unreservedly. Those who moved the motions of no confidence in the leader of this party knew full well that they grounded their ambitions in an effort to destroy this party by attacking the head of the party. They made it clear in other statements that their intent was to destroy this party, and therefore their efforts had nothing to do with the lack of confidence in the leader, but everything to do with their wanting to destroy the leader, and therefore the party, and the party today resoundingly rejected them. They know full well that they could not have succeeded and did not pursue their trouble-making efforts in the face of the National Council. I pause here a minute, my lady and my lord. Remember, there were two motions that they had filed, and they withdrew these motions. So the leader obviously didn't have his day in dealing with those motions. So it is in that context that he's saying that. They would do so in the media in solidarity effort where they had open space and place to spread their poison. But here where it mattered, where their voices should have been heard, so the party would say whether we agree or reject you, they ran away like cowards. And then to have found that the very personalities who have been making all the mischief on the outside, that this letter has come to us, and I make no pronouncement as to its authenticity, but maybe all the media they had been garnering for the last several weeks or months, maybe they should go to the media and explain whether they did in fact put their signature to such a letter, betraying their party by disclosing its membership list, something we hold very dear. And let me explain why a membership list is important. When people join political organizations in this country, they are much afraid by by that they could be discriminated against by the mere fact that they hold membership in a party. Many may not feel that way, but many do feel that way, and that is why we held it in terms as a matter of high confidentiality. And if it is true that they did do these things, then that is the highest level of treachery that we condemn in politics generally and the COP unreservedly. And that is why their suspension without a finding of guilt, yes, but we'll ask for a proper and full investigation to determine the facts in this matter. And if they prove true, well, then I will say that the next step is for expulsion from the party. My lords and my lady, I've read this several times myself, and unless I have it wrong, I do not see in the context, even on the natural and ordinary meaning, there is anything in this that is defamatory, and I do not, of the respondents, and I do not see it taken in the political context, in the principles of law that I've referred to, it can be regarded as defamatory. Unless I could assist the board.
I think Lord Lloyd-Jones has a question for you.
Just one matter, Mr. Maharaj, if I may. You invite us to consider this statement and to ascertain whether it's got a defamatory meaning in the particular context of party politics within Trinidad and Tobago. It might be said against you that the judges in Trinidad and Tobago are better placed to form an evaluation of that than we are.
Well, my lord, I did refer earlier in my submissions that what the board has to look at, yes, the board will look at cases in which you would find cases in which there are no errors of law that the Court of Appeal has made, and therefore the board would not intervene. But this is a case where they are vitiated by errors of law, as I've pointed out. And in my respectful submission, where there are serious errors of law, like I've submitted in my respectful view, that the board has a duty to intervene. The board is the final Court of Appeal of Trinidad and Tobago, and there would be cases that the board would defer to a decision of the Court of Appeal, but in my respectful submission, where there are naked errors of law, patent errors of law, the board ought to intervene and to have it corrected, because having regard to the principles of law, it can set a serious precedent in the Commonwealth, not only for Trinidad and Tobago, but for other countries of the Commonwealth.
Thank you, Mr. Maharaj.
Much obliged.
But there is an implicit criticism that if they don't go to the media and explain or deny whether or not they sign the letter, isn't it implied that that's something which they ought to do?
Well, my lord, sorry, my lady, I think that was said in the context that you have filed motions, you have withdrawn them. If it is that you have not said these things, you have not signed a letter, we would expect you to go to the media and explain.
Which didn't happen.
No, I don't think they went to the media. I came into the matter very late. I was only in the Court of Appeal for the submissions. I was not at the...
Can I just ask something?
Did you have a question?
I did, yeah.
Lady Black has a question for you, Mr. Maharaj.
I just want to go back to the text of what was said, please. It seems that the first almost half is not the sting of the alleged defamation. The first half describes what has been happening in the council, doesn't it?
Yes, my lady.
And the sting seems to start when it says, and then to have found that the very personalities, and goes on to the letter. Is that the way in which things have been approached? Because there are no qualifying words like if it be true or it is alleged in the first half of this text. They come in the second half.
Yeah, I think your ladyship is correct. The first half seems to be dealing with the motions,
right,
and the allegations and the motions.
I thought, Mr. Maharaj, that you would say to my lady, your ladyship is absolutely right. Please look at paragraph 9 of the judgment at first instance on page 601. Please look 9 lines down. where we all read, if you have you got it, Mr. Maharaj?
Yes, my lord.
601, 9 lines down roughly. The very narrow issue to be examined ultimately is whether the publication of that letter should have been left. So I think that the judge was drawing the line precisely where Lady Black identified. You agree with that?
Yes, my lord.
Now, any more questions? I think not.
I'm much obliged.
Mr. Maharaj, thank you very much. Mr. Poole, there would be a few minutes for you to address us if you wanted to do so. Thank you. Very well. Well, then, who's going to start? Mr. Campbell, are you going to go first? Or Mr.
I will go first, my lords.
Mr. Gilkes, you're going to go first?
I will.
Very well.
No, my lords, we too, I think I can speak for Mr. Campbell on this, intend to rely on the submissions that we filed, in which we sought to set out as clearly as we could the arguments.
Mr. Gilkes, I speak only for myself, but I'm having difficulty hearing you clearly. Can you speak very firmly and loudly, please?
I will attempt to do so, my lords.
Thank you.
Is that better?
I think it is better.
Now, I was indicating that I think I can speak both for myself and for Mr. Campbell when I say that it is our intention to rely on the submissions that we filed, in which we sought to set out in as much detail as we could the arguments that we wish to make. What I do wish to address your lordships and your ladyships on would be the question of the interpretation of the words. Because in my respectful view, it is a meaning case. It's not really a justification case, because the respondents never complained about the meaning that Mr. Justice Musai found the words had. That was not our complaint. And even if your lordships were of the view that the question of justification could be dealt with at this stage, it doesn't address the central issue as to whether or not the words we complained of had the meanings that we say that the words had. So my attention really is to focus on.
Suddenly, you became extremely loud, so loud that we couldn't hear. Was something knocked by your microphone at that point? Can we understand why that happened and hope to avoid it again?
I think I came closer to the microphone with a view to having you hear me. I'm wondering if you're hearing me clearly now.
Reasonably. So proceed.
Yes. So I was indicating, my lords, my ladies, that it is my intention to focus on the question of the meaning of the words, because in my view, it is a meaning case. I don't think that it matters whether one justifies the meaning that Mr. Justice Musai found, because we never complained about that. We complained about the meaning that Mr. Justice Kokaram found and that the majority found also. Now, as regards the meaning,
Mr. Jolks, I'm sorry. I want to get this absolutely clear. Are you saying you don't quarrel with the meaning attributed to the words by Justice of Appeal Musai?
I'm saying that it's difficult to say that the words did not have that meaning. It's another matter whether one is entitled to complain at this stage or raise the defense of justification at this stage. But I'm saying that even if the words did have that meaning, and I think it could be argued that they do, what we complained about was the meaning that Mr. Justice Kokaram and the majority of the Court of Appeal found that the words had. And your lordships and your ladyships, in my respectful view, would still have to consider whether the words have that meaning.
Yes.
Now, as regards the meaning of the words, if I may take you to the paragraph that my little friend just read, setting out what was said by the appellant.
Yes?
And of course, the sting, of course, does come in the second part of the statement that Mr. Ramadhar made to the press. But when Mr. Justice Kokaram considered that he had given a lot of substance to the charges that this letter had been written by the respondents, in our view, it's because in the beginning of his speech, he spoke about his feelings about the charges that had been originally placed before the National Council. Charges that these claimants were, or these respondents were mischief makers. And then what he goes, mischief makers because they were criticizing the party, because they had brought these motions complaining about the way in which the party had interacted with the national government, the request that they pull out of it, and also the suggestion that the leader had not really performed in the way he ought to have. So what Mr. Ramadhar is doing is characterizing these interventions by the respondents as being purely mischief-making. But more than that their intention was to destroy the party, as if criticism of the party was tantamount to its destruction. Now, this was a National Council meeting that had been reserved for this particular discussion, because there were very serious concerns raised by members about the declining influence of the party. And in fact, of course, coming in the wake of the local government elections, the declining fortunes of the party. So that the issues that were being raised by the membership, and that's really who these respondents were. They were members of the party sitting in a body whose purpose was to discuss issues such as this. Where is the party going? What has it departed from its moorings? And of course, they withdrew their motions because they considered, first of all, that persons who were invited to participate and to vote on the motions were persons who were not properly there. And that is to be found in the witness statement of Mr. Hanamji, the second named respondent. It's paragraph 13 of his witness statement at page 149, volume 1.
Do you want us to go to that?
I don't think it's necessary.
Very well. We've made a note.
Where it can be found.
Very well.
So that the reason for the withdrawal of these motions is that it was considered that we have come here to debate a serious topic, and you have overly restricted our speaking times. And you have put another item on the agenda for discussion when these motions were adjourned from time to time to permit us to deal specifically with this. And also, you have invited persons to vote on the motion who ought not properly to be here. So that was the objection that was raised at the National Council meeting, and that is the reason why these motions were withdrawn. It was not a case of the respondents simply running from the opportunity to vindicate all that they had managed to say in public in their various press conferences, as the political leaders sought to characterize them. So what he then proceeds to do in his speech is to say, well, he's taking advantage of the fact these motions were not debated, and is saying, well, this is proof of the fact that these people were merely mischief makers and their objective was to destroy the party. And because he made such strong statements, when he then came to say, and then to find that these are the same people who have written this letter, it is in my respectful view, it is for that reason that Mr. Justice Kokaram thought that he had given such substance and credence to the...
Did he say that your clients had written the letter?
Well, he said purported, but he said that to have found that these are the same people who, in his view, had been on an exercise over many months aimed at destroying the party. Now, here we are finding that there is this act of treachery that, admittedly, he says that they have been accused of, but of course, casting it as proof positive of their intention to destroy the party, he links it to all of the other conversations that had been taking place and to the fact that the motions had been withdrawn. So he puts in an element of truth, which is that the motions were withdrawn, the fact that they had been criticizing the party. He then adds his comment that I think that obviously this was intended to destroy the party, and then he introduces the bombshell of the letter. Now, it is in those circumstances, I think his lordship, Mr. Justice Corcoran, concluded that it seems clear to me that the intention was to suggest that this is in fact something that they did do. So the qualifications that he interposed, really those qualifications were diluted by the powerful remarks that he made, which suggested that they had done it.
And that's confirmed, that submission, would you say, is confirmed by the fact that he effectively challenges them to tell the media, did they sign?
That's right. And he's saying, well, you've gone to the media in the past, so go to the media now. Go there now and defend yourselves. Because he's decided that this is going to be trial in public. In that setting, it makes the question of an investigation simply by the way. And certainly it cannot be dismissed that when there came to an investigation, there was no attempt made to justify or to support anything that was said. And even when there was a resolution of the matter in the respondent's favor, there was never any attempt by the party or the political leader to put in the press the fact that they had been vindicated. And in fact, at trial, he maintained that he considered that there was no vindication at all. They had not been exonerated as far as he was concerned. They simply had not, the party had simply not been able to prove what he said he believes they had done. So, when my learned friend, Mr. Mirage, says that there was not any proper consideration given by the majority in the Court of Appeal or by the trial judge to the fact that there was a political discussion taking place, it's not really supported by the facts, because both the trial judge and the majority of the Court of Appeal spent a considerable amount of time outlining the background to the suit, indicating that there was this heated debate in the Congress of the People about whether or not the party should remain in the coalition and whether or not the political leader had done right by the party in keeping it in the coalition. All of them prefaced the remarks that they then made about the issues in the trial by pointing at great length to what the context was. The only difference between their treatment of the issues and Mr. Justice Musai's is that Mr. Justice Musai considered that because it was a political matter, quite frankly, all of this that the political leader did was okay. Now, when Mr. Justice Musai talks about the context, and part of the context that he saw was the fact that you had a local government election a few weeks before, and in the run-up to that local government election, you had the publication, you had the opposition party saying that we have information that suggests that members of the Congress of the People who are standing in the local government elections, they are not actually members of the party, and that breaches the rules of the Elections and Boundaries Commission, etc., etc. Now, he's saying that this is part of the context, and therefore he's emphasizing how sensitive a topic it was, because members of the COP must have been concerned, A, about their business being in the street, and B, about the fact that members who were being put up to represent the party who were not in fact members of the party. And then you have this, the happenstance of this letter that was written apparently on the 1st of October to the opposition party, signed by these respondents. It comes into the National Operations Center of the Congress of the People at the beginning of October, and mysteriously sits there for more than a month, only to be opened on the morning of the National Convention, on the 10th of November, which contains this explosive evidence that it was the respondents who had written to the opposition party and disclosed a CD containing all of the information, confidential information about members of the party. You have this happenstance, I have to call it, because there has not been any explanation for why it is, how it is that this letter could have come in, and given its gravity, it never came to anyone's attention. And when it did, nobody thought it proper to bring it to members of the executive, including the political leader, so that he could see what it contains. Nobody did that. All that happened was that there was this motion that was to be moved from the floor of the National Convention on the morning of the meeting, and then this letter is being read in and included by way of amendment in that motion. And of course, it contains all of this explosive information. Now, I say all of that, my lords and ladies, because when one considers the explosive nature of this disclosure contained in this letter, it would seem that that makes it more likely that because the issue is so sensitive, members of the party and members of the public to whom the political leader directed his remarks were likely to believe that the party had finally caught the culprit. They were not likely, on hearing the political leader hosting a press conference after a national convention at which the question of the leadership of the party, well, the performance of the leadership of the party and the question of the party remaining in the coalition was to be discussed. That's why the press were gathered there. That is why there was so much attention to the whole thing. Because everyone knew what the purpose of the convention was. And then the upshot of it is that these people have withdrawn their notices, and we have now caught them as being the persons who had disclosed all of this information, which had made so much press at the beginning of October, when the opposition party had come to the press and said, well, this is the information that we have. So that you have this setting for all of this. And it is in that setting that Mr. Justice Musai suggests, well, I think you need to consider it. But of course, if you do consider it, and I believe that the majority of the Court of Appeal and the trial judge did, if you do consider it, it creates a setting in which it is all the more likely that members of the public or any members of the party viewing and hearing what the political leader had to say would construe him as saying that we have found the people involved. He goes on to emphasize how much this amounts to treachery and a betrayal of the party. The implications of disclosing this kind of information. We live in a small society. People could be victimized for political allegiances and that sort of thing. That's why it's so important that we deal with this. And that's why we've had to suspend these people without a finding of guilt. Now, of course, he's saying that And Mr. Maraj, I know, is relying on those remarks as saying, well, he's saying there's no finding of guilt. But what he is in fact suggesting to members of the public by juxtaposing his complaints about mischief making, the disclosure of this letter, and in his remarks about what the letter means, if true, is that he's clearly telegraphing that it's true. I don't know that anyone heard in there the few words that he uttered, which amounted to the disclaimers that they're relying on today. So it seems to me the context does not help to convince that this is a publication that anyone, any reasonable reader or hearer of the remarks would have considered to be remarks that suggested that, oh, we are merely going to conduct an investigation. Don't take anything more from it than that, which is what Mr. Maraj will have you believe today. Now, on the question of the role of the board in supplanting your views for those of the trial judge, I mean, I would urge my lords and my ladies to observe the discipline restraint that Lord Kerr has recommended in Stocker and Stocker, and to bear in mind that there really is no basis for saying that the judges who are locally, who are present locally and who have adjudicated upon this matter have simply missed the fact that this is political speech. They simply did not appreciate sufficiently that this was what the nature of this discussion was, and did not give sufficient weight to the fact that this was a very explosive political issue that deeply concerned members of the Congress of the People. I don't think there's any basis for making that finding at all. It seems to me that they're properly well placed, having heard the remarks and being familiar with the way in which the politics works in this jurisdiction, to say, well, I don't see any reason, I can't see how this would not be the impression that is formed by members of the public hearing these remarks. Now, I am well aware of all of the authorities that suggest that when you are talking about persons operating in the political arena, there is need for a certain amount of thick skin. And of course, I think we all could do with a bit of thick skin in the face of criticism. But there is a difference between thick skin and simply being required to suffer character assassination, which, quite frankly, this was. Mr. Maraj has emphasized the gravity of the matter, and I emphasize it as well. These were very grave charges, because one may have differences within a party that you wish to resolve and differences in perspectives. But the question of simply taking the party's confidential information, breaching a trust insofar as it is suggested that Mr. Kishore Ramadhar, was the keeper of this information, that he took this information, breached his responsibilities as an officer of the party, and disclosed it to the opposition. That's a totally different thing. It's completely different. It goes well beyond conversations and disagreements that one will have within a party. And it can properly be characterized as an attempt to destroy the party, which unfortunately the appellant considered the criticisms that he was receiving about the party's performance in government was. He saw it as being an attempt to destroy the party. And that's quite frankly how he saw it. He saw it as nothing more. He saw nothing constructive in what they had to say, even though the party's performance at the polls in October of 2013 and its performances since have indicated that there has been a falling out of favor with members of the public, so that the party is no longer as attractive as it used to be. And that is the discourse that the respondents sought to have the party embark upon. And it's a discourse that the political leader has consistently described as being an attempt to destroy the party, rather than to have the party conduct some sort of self-examination. Now, in my respectful view, your lordship,
Mr. Gilks, Fortunately, because you speak so clearly, we can hear, I think, about 99% of what you said. But there is the occasional word that, speaking for myself, I can't hear. So can you speak a little bit more slowly?
I will.
Thank you.
And it's an unfortunate Caribbean trait, my lord.
Yes.
Now, I was going to say that when we talk, I think your lordships have quite correct, in my respectful view, observed that there is a difference to be identified between conversations that take place between politicians and the conversations that they may have with others. And I know that it may be tempting to describe the respondents as politicians simply because they were members of a political party and they held some sort of office. At least two of them did. They held some sort of office within the party. But none of the respondents has ever held any public office of a political nature. And they were members of a party. One was the Secretary of Education, the other one was a constituency head. And they felt that they were the persons best placed to remind the party of what its moorings were and what its principles were. And these motions were intended simply to be that. The party calls itself a Congress. It calls itself the Congress of the people. Implicit in those words is that people speak to each other about what the objective of the political movement is. This was the exercise upon which the parties, my clients, sought to embark. And of course, the respondents, all of them, when they moved their motions, that was the discourse on which they attempted to embark. And what they were met with in this speech made by the political leader is really an attempt to destroy their reputations for having the nerve to challenge the performance of the party in a national congress, which is a function of a national congress. So to compare the situation that we had in our case with what you had in Roberts and Bass, I'm not sure if that's how it's pronounced, where you are talking about persons who are contesting a particular seat in a constituency, and in which they may say all sorts of things about each other. To compare the two things, in my respectful view, is not appropriate. Furthermore, one has to note that when you look at what views were expressed by the majority of the judges in that case, their focus was entirely on the question of there having been a constitutional decision which suggested that the common law relating to libel and what was permitted in political speech as between contestants in a political race. Their concern was the courts below having found that privilege was established, ought the courts to have found that there was malice that displaced that privilege, and ought they have found it on the evidence that was available, given the view expressed by the High Court of Australia in Lange that you are supposed to give this much more latitude. Now, it does not appear from reading the decision that the High Court of Australia was attempting to depart all that much from the principle that you have to have a basis upon which the privilege is to be established, and then, of course, a basis upon which it is to be displaced. They separated two categories of the ordinary category of qualified privilege from the constitutional one relating to discourses between candidates. But in any event, the case turned essentially on whether or not the circumstances that obtained in a particular case were circumstances that justified a finding of malice. What Mr. Justice Kirby does in his separate judgment is to make observations about why he felt that there was need to change the approach that is taken in political matters by suggesting essentially at paragraphs 171 and 172 that, the politics in Australia is not for the faint of heart. I think when one looks at the leadership changes and the way in which they are effected in Australia, one would must necessarily agree that it's not for the faint of heart. And that the discourse amongst politicians often becomes quite robust, sometimes caustic. I mean, it does appear to me, and I say so respectfully, that the suggestions that it is the purpose of those who support candidates in an election is necessarily to harm their opponent or to harm their reputation. I'm not sure that necessarily that is the kind of thing that ought really to be endorsed. But in any event, they are his observations alone. They are not observations with which others associated themselves, notwithstanding that they were coming to the same conclusions on the merits of the case as he was. So in my respectful view, these are very strong views that the majority did not feel that they were prepared to associate themselves with. In any event, the suggestion that the common law ought to respond to a decline in standards of behavior by simply recognizing that this is the new normal and that is therefore what the law should be. I do not know that it is an approach that ought to be commended to this board. At the end of the day, there is a balancing exercise, whether or not you talk about the freedom of speech or the freedom to express political views enshrined in the Constitution, or you are speaking about a limited type of right that you may have had in relation to candidates in Australia. You are ultimately balancing constitutional rights to freedom of expression against age-old rights to the protection of your reputation. And it is important, my lords, to remember that in this jurisdiction, because of the savings provision in our Constitution, one does not simply read rights that existed prior to the introduction of the Constitution in the light of the Constitution itself. It is well established that, for example, the death penalty has not been abolished merely by the introduction of a provision in our Bill of Rights that says that you are not to have cruel and unusual punishment. That has always been the position in relation to the interpretation of our Constitution. But even if it were not so, once you are balancing rights and talking about the right to political expression versus the right to reputation, there still has to be some weight that one places, even if you are a political being, on reputation and the right to reputation. It cannot simply be that you can say whatever you like and you can simply destroy someone's character because you have the right to express your political views freely. That could never be a proper balance to strike. So that in my respectful view, the board ought to treat very reservedly with the observations made by Mr. Justice Kirby. The remarks made in the other case that your lordships referred to as one of the others, involving...
Mr. Justice Warby case.
Yes.
Barron and Healy against Vines.
Yes, my lord.
Yes.
It does not appear to me, having looked at paragraph 86,
Yes.
that there is anything in there that departs from the traditional approach on these matters. When His Lordship says the primary focus of this jurisprudence is on the need to avoid chilling legitimate political expression by ensuring that those who speak out in good faith on political topics are not unreasonably exposed to findings of liability for defamation. I've always respectfully understood that to be the approach that one takes. And the question really is whether you have spoken out in good faith. But what we complain about in this case is that you are using words which attribute to us a very serious accusation that we have betrayed our party and acted with treachery. We say that for the various reasons that are listed in our submissions, in the last two paragraphs of the submission, that there were so many reasons why the political leader ought to have been suspicious about this letter that came so long after it appeared to have been written and was delivered at the, allegedly delivered at the National Operations Center, indicating that my clients were responsible for the authorship of this letter, providing sensitive party information to the opposition party. This comes to him, in fact, not even to him, it comes to him because he is sitting on the head table in a national convention, and it's read out from the floor of the meeting on the 10th of November 2013. And he is so convinced of its authenticity that he feels compelled to tell members of the public that this is further proof of the treachery of these persons, whose treachery
Did you just say that he told the public that it was further proof of treachery, Mr. Gilks?
I did say that, because to my mind...
Is that a slip of the tongue, or do you suggest that that is the meaning of what he said?
I'm saying that is the meaning of what he said. That is the meaning of what he said. Because he spent the opening remarks saying that these persons, their objective was to destroy the party. That is why they said all of these things in the media. They tabled motions, and they have not come forward to support them. And then to find that these same people are supposed to have put their names on this letter, he's basically saying, well, this is what they did. This is further proof of their treachery. This is further proof of the fact that their objective all along, they've escalated. They were engaging in motions and that sort of thing. The time has come to present their motion.
As you know, Mr. Maharaj says there are three references by the appellant in the address to an investigation. There will be an investigation. There will be an investigation. Let's see what the investigation says, and if it turns out that, then they will be expelled. Well, Mr. Maharaj says that is quite inconsistent with his having conveyed that it is already proven that your clients wrote the letters.
Well, of course, he has inserted those disclaimers, really, after having made out his case for why this amounts to treachery and why it amounts to the mischief-making that I've complained about in the early part of my speech. So he spends his time developing his arguments for why it is this must be regarded as being in the same vein as everything else that had gone before, and in the vein that Mr. Ramadhar chose to characterize it as being attempts to destroy the party. he says all of that. He drops the bombshell of the letter, and then he starts to introduce his disclaimers. And even then, he returns to speaking about why this is such a very serious charge. And then he reintroduces his disclaimer again. And quite frankly, his lordship, the trial judge, and the Court of Appeal were entitled to say, well, I don't know if having said all that you've said, and particularly as it came on the heels of what the chairman had said, setting out the details of what was contained in the letter and that sort of thing, I don't know that you can simply throw in, by the way, we don't know if all of this is true, and escape what you've managed to put together for the vast majority of your speech. The speech itself wasn't very long, but what certainly would have stood out to members of the public would have been that, we are coming to tell you what transpired in this national convention that was convened for the purpose of debating whether we stay within the government. These people have withdrawn their motion. They haven't had the guts to come and support any reasons why we should withdraw from the government. And in fact, all of this is really about their attempts to destroy the party. Oh, and by the way, there's this letter. You remember that incident that took place at the beginning of the month, where our information was being talked about by the opposition party? Well, here it is. We have this letter signed by these people, the same people who I just spoke about. Here it is that we have this letter. And this letter seems to be enclosing a CD with all of our information, and it's written to the General Secretary of the opposition party. All he didn't do was drop the mic because he wanted to make then his disclaimers. So he makes them, and then he returns to talking about the treachery and the seriousness of the charges, and then he drops his mic. So the impression that the language would have created certainly would not have been, well, there's something here that we need to investigate. So we're going to go investigate it. What he essentially conveyed to members of the public was that we have found these traitors who a few weeks ago would have put this information to the opposition party. We have found them. They are the same people who are talking about us withdrawing from the coalition. That's the same people. And that was his objective in making this press conference. Now, it remains to be seen, it remains a matter for your lordships and your ladyships, whether you agree with our submissions in paragraph 73 of our submissions, where we say, well, the judge ought to have made findings of malice. And there certainly was a basis for the Court of Appeal to make its own findings of malice, based on the findings that the judge did make. Because we set out in some detail the evidence that was before the trial judge about the circumstances leading to this letter being revealed on the morning of the National Convention, and the complete absence of interest by all of the defendants in the action who were responsible or who played a part in this.
We read that, obviously, Mr. Gilks. But, was that evidence about the mystery behind the production, the late production, as you say, of the letter? Was that addressed by the trial judge or the majority?
The trial judge did not point to any of those submissions. What he did draw a conclusion that, given the circumstances in which the letter came to the political leader's attention, that there was really no basis for him to have been so sure that it had been penned by the respondents. He draws that ultimate conclusion. And it is because he drew that conclusion that the majority of the Court of Appeal were of the opinion, well, having drawn those conclusions, we think that there's evidence of malice, so that even if there were privilege, it ought to have been displaced by a finding of malice. You didn't say you found malice, but you certainly made findings which to us appears to be findings of malice. And that's what eventually the Court of Appeal did. Now, he didn't point to all of the things that we said in our submissions. But we did manage to at least get him to say that, I don't see how you thought that this could have been true, or that you could properly, given how it came to you, take it to the press in a press conference a few minutes later. I don't see how you could have done that. So, in my respectful submission, my lords and my ladies, it seems to me that the words did have the meaning that Mr. Justice Kokaram found, and that the Court of Appeal also found. I mean, they were careful to say, well, look, he's made this finding, we can see why he did. And therefore, we don't feel we should be disturbing the decision that he made. In my respectful submission, that was right. Because I do not know that you can say that, as Mr. Justice Musai did, merely looking at the gravity of the charge and the fact that there had been this disclosure of confidential information to the PNM, and this appeared to have been the source, that was sufficient reason for the political leader to say, oh, I think there is every reason to believe in its truthfulness, and therefore I should put it to the public without testing it. And basically, that is what Mr. Justice Musai concluded. And then he goes on to say, well, I think the words had this particular meaning, which is that you should conduct an investigation, because as far as he's concerned, all he got from what the political leader said was that there was going to be an investigation. Quite frankly, the majority felt that, well, I think you would get a lot more from the words than that. And what we think you would get is that here is you suggesting that this is all true. Yes, there must be an investigation. It's like saying, well, we have caught the murderer. Of course, there will be a trial, but we've caught him. And that's basically what it was. I think it was like a lynching, which is why I think Mr. Justice Kokaram described it as hanging them out to dry. Because he simply went to the press and said, well, look, we've caught these people. All right? So that, in my respectful submission, the words clearly mean what both the High Court and the Court of Appeal found. And in my respectful submission, that ought to be sufficient to dispose of the appeal. I don't respectfully believe that the justification point takes us any further in terms of the real gravamen of the issue that your lordships have to consider, which is really the question of the meaning of the words.
Now,
Unless I can assist you.
Now, Mr. Gilks, you've made your position very clear about meaning, and the board is extremely grateful to you. But if Mr. Maharaj is right in saying that the meaning was, the gist of the meaning was that there are grounds for an investigation here, would you be able to argue that that meaning was not justified?
I don't see how I could.
No.
I don't see how I could. I think at least it conveyed that meaning as well.
Yes, and so I think both sides agree, actually, that justification falls away. And this is really a dispute about meaning.
That certainly is my view, my lord.
Yes. Now, what else did you want to say, Mr. Gilks?
That's all I propose to say. As regards the other issues, I intend to rely on the submissions that we have already filed. So unless I can assist your lordships or your ladyship any further.
Well, let me just check with my colleagues. Thank you very much indeed, Mr. Gilks. Now, Mr. Campbell, were you proposing to add anything? You obviously associate yourself with everything that Mr. Gilks has said.
Yes, my lord. In addition to which, I wish to associate myself with what Lord, your colleague Lord and lady has said this morning. That is to say that this conversation that took place at the National Council meeting, had it been a conversation circumscribed and related only to the meeting, then the position would have been different. The catalyst was that they went to the press with it. So this argument, and this is stated by Justice Pokuram at paragraph 9 of his judgment.
Well, let's just look at that with you, Mr. Campbell.
Indeed, Miller.
601.
Yes, it's 601, Miller.
Yes?
The very narrow issue to be examined ultimately is whether the publication of that letter should have been left for a more private inquisitorial setting rather than the open discussion at the National Council meeting. And it continues, or worse, the subject of a televised press conference to the national media. And it is that catalyst that creates the problem and effrontery to the respondents.
Mr. Campbell, of course, Mr. Maharaj says that in these political situations, the public has a right to know what's going on. What do you say about that?
I have a great difficulty in accepting that. The public has a duty to know of very succinct statements about allegations, but you don't go into details of saying what was said in the third paragraph of Prakash, the appellant's statement. That he actually speaks to treasury, he actually speaks to a letter that the respondents were not in a position to add, detract, or say anything in respect of those matters. So what was portrayed to the public was a one-sided view, which we do not countenance in our legislation or by the common law.
Yes?
Now, furthermore, Mr. Maharaj has made the point that this matter is sensitive to Trinidad and Tobago, that there are special circumstances in Trinidad and Tobago that does not obtain in any other jurisdiction in the Caribbean, for that matter, far more in the Commonwealth. But if this is be the case, Melad, then we have the first instance judge and 2 judges in the Court of Appeal who understand the conditions in the Trinidad and Tobago. And Justice Smith was very clear in several paragraphs of his judgment that the first instance judge, Justice Kokoram, had an opportunity to hear the witness, to hear the respondent, to see the letters, in coming to an impression of, forming an impression as to what the decision should be with, that in fact the words were defamatory. And Justice Smith said in no uncertain terms that he saw no reason to interfere with that judgment for that. So
Mr. Campbell, could I just ask you on that point, why seeing the witnesses and hearing them giving their evidence would give the judge any advantage in deciding what meaning the words bore and whether that meaning was defamatory?
Yes, I understand what you're saying, that the language should speak for itself as opposed to the countenance of the witness. But the cross-examination of the witness and the local circumstances, as Mr. Maharaj has pointed out, yes, would have added to the situation as to the defamatory nature of the statement.
Well, at the moment, I'm not clear why that should be. I'm not sure why the judge would be assisted in that way.
But let me put it, if he would not be, it does not detract in any way from the situation. He may not be, if to take your lordship points a bit further, what was said, seeing the witnesses and so on, did not derogate from the position that the words were defamatory. do not have I answered your question, Miller?
Thank you for your answer.
I didn't quite hear your answer clearly. Could you just repeat it?
Yes. Seeing the witness, while it may be, I am rephrase it in a different manner. Seeing the witnesses, I am saying, was not a negative influence on the judgment or the impression of the judge. The words spoke for themselves. The paragraphs in the form in which the first paragraph, there was nothing wrong with that. The second paragraph, there was nothing wrong. But the third paragraph, which he speaks about treachery and speaks about the letter, the language in those paragraphs commended themselves for being a defamatory statement. And that the disclaimer didn't reach to the level of the danger that was pointed out by those paragraphs. It did not equate. So what you were left with were bald allegations taken to the level of guilt to the press. Now, as I said, Milan, had this been kept at the level of the National Council, then there may be some argument that it was not dangerous, or it was not defamatory, or it may be a borderline case, but it went beyond that. And the question is, and I think your Lordship has asked this question, whether the press had an interest. What was the interest in the press in knowing of this? What was the public at large interest in knowing about this? And our answer is that the public had no interest in this. There are many things.
Mr. Campbell, could I ask you a question? I hope I'm in your picture over at your end of the video. The judge was obviously quite strongly of the view that the letter was not something which it was appropriate to mention, even on the basis that it gave rise to an allegation that it came from the defendants, in a public forum. He seemed to have been very clearly of the view that it was appropriate only to mention it, as it were, rather more privately while it was under investigation.
Yes.
That, of course, would be relevant to questions of privilege and response to attack, and possibly even to malice.
Yes.
But might it be said that the judge allowed that quite strong feeling of his to affect his view about what it actually meant, that the statement of the appellant actually meant, i.e. about meaning?
Yes, but that is why I went further, Milan, to speak to, or worse, the subject of the televised press conference. So even assuming for one moment, but not admitting that the judge may have been colored by that fact, I am saying that where our case is the question of the press conference. It's going beyond. It's going beyond what is acceptable or that may be permissible in the circumstance. A certain amount of debate is permissible within the confines of a meeting. And I dare say these were not politicians.
Thank you.
But when it comes to saying they should go to the press and say whether or not they signed the letter,
Yes.
Is he, would you say, challenging them to take that action with the idea that if they don't do it, there's some inference to be drawn?
Yes, but that is immediately followed by the statement that an investigation is being set up.
Yes.
So the question is, what is the truth? What is the thing? What is in the mind of the speaker at the time? An investigation has been set up. An investigation which he doesn't take part in. An investigation that a report has been made. A finding has been made that these things are not true. And furthermore, although this may be excessive now, in the cross-examination, he says that he believes they were true.
Yes, thank you.
Yes. So, in winding up, if your lordships may permit me, as my friend Mr. Maharaj has said, that the peculiar circumstances of Trinidad and Tobago would warrant special attention to this matter. But he goes on to say, but I have said that the judges in Trinidad and Tobago, in a majority, have formed the opinion that this was defamatory within the laws of Trinidad and Tobago, within the culture, within the situation in Tobago. But on the other hand, Mr. Morales says that this now would be setting a precedent for the Caribbean and other places, when he has already admitted that Trinidad and Tobago's circumstances are special. So he is, in one way, saying one thing, and in another way, saying another thing. I can use the words approbate and reprobate.
Anything else then, Mr. Campbell?
Just in closing, now, again, Mr. Mirage makes heavy weather of the Australian situation vis-a-vis the Trinidad situation. In our situation, we have a constitution and the right of freedom of expression. But we have a saving clause. And the common law is alive and well side by side. So defamatory statements are not permissible, or the latitude that will be given in the Australian situation differs considerably from ours, where they don't have a saving provision. So that is critical, because on the other hand, I go back where he says our Trinidad situation is different from the rest of the Caribbean, the rest of the world. But yes, he introduces the Australian situation, which again is different from ours. So I'm saying to your lordships and ladyships that we have to be very cautious in this matter, in attempting to extend the boundaries of acceptable speech. Because what it may happen in those circumstances, we may have an inequitable political environment where, depending on your financial or other success, you may be able to make certain statements about somebody who has just a civil will to join a party or to be big, have their voices. And you can make statements about them in the press, which they are not in a privileged position or in a position to reject. So it would lead to an inequitable situation in the social and political environment in Trinidad to extend the boundaries beyond what is permissible under our constitution as freedom of expression, side by side with the common law that allows, that speaks to defamation and the boundaries that you're allowed to speak for freedom of expression. Unless your lordship and your ladyship would like to hear me on anything else, that would be my contribution.
Mr. Campbell, thank you very much indeed. The board is really grateful to you. Thank you. Please sit down. Now, Mr. Maharaj.
Yes, my lords and my ladies, I would not take the 15 minutes, but I just want to...
Yes.
My lord, the respondent submissions seem to focus in the first part of the submission on the first half of the appellant speech. My learned friend, Mr. Jelks, in the opening of his submission, seemed to have been focusing on the first half of the appellant speech. But we submit, as Lord Wilson correctly observed, that part of the press conference was not an issue at the trial. Paragraph 9 of the judgment of Justice Corcoran has made that clear. And when you go to the focus was on the second part of the appellant speech. And when you look at the second part of the appellant speech, in respect of the submissions made, there was expressly no finding of guilt. No finding of guilt by the appellant. As a matter of fact, he made it quite clear he made no pronouncement as to the authenticity and without making any finding of guilt. Thank you very much. we do respectfully agree with Lord Briggs that Justice Corcoran's judgment on meaning may have been inappropriately influenced by a strong view that the letter should not have been released to the public at all, or should not be discussed at the public. But it would seem to us that what is important here is that Justice Corcoran should have simply focused on the words spoken in the political context. And the interpretation of those words as to whether they are defamatory or not does not depend upon evidence. It is a question, in our respectful submission, of pure interpretation. Is a question of law as to whether those words are capable of having a defamatory meaning. In respect, we submit there's no principled reason to restrict the principles set out in cases such as Roberts and Bass to just politicians. And as I submitted to the court, cases such as Mayer and Hungary make it clear that the principles extend to political parties. That is at paragraph 81. And we do also have section 4E of the Constitution, which refers to the express right of holding political views and joining political parties. And we submit that the common law, it's not a matter of extending the boundaries. The common law has already developed to take into context the political context in which statements have been made. And in our supplemental case, we have showed some of those cases, and the common law is always developing, and in the Australian cases, we see that also, my lord and my ladies. The Lady Arden, I made some inquiries, and I was told, my client sent us an email, and I was told that in volume 2, page 349, to say that the respondents did go to the media after the press conference. And can I take your lordships and ladyship to volume 2? It's at page 349.
Yes, this is the Newsday article, isn't it?
Yes, and COP suspends 3. And then you see the last column. I will ask your lordship and ladyship to look at the last column there. Meanwhile, Ramcharan in a telephone interview last night, etc., etc. My learned friends kept on talking about charges. My client did not talk about charges. My client talked about an investigation into the allegations. On the question of malice, I just wanted to say there was no finding of malice at first instance. The majority of the Court of Appeal held that the dominant motive of the press conference was to injure the respondents, and this was evidence of malice. We have set out at paragraph 66 of our printed case at page 865 that the majority of the Court of Appeal were wrong to make this finding, and as at first instance, the respondents failed to discharge a burden on them proving malice. And we also submit that if one looks at what was said by the appellant, it was a balanced account of what happened at the meeting, and particularly that the allegations against the respondents were unproven and would be the subject to an investigation. We submit this is inconsistent with any allegation of malice. In respect of the submission about the local courts that my learned friend submitted, it is no doubt that the local courts can have a decision of the local courts, can have a better understanding in some cases of local issues, such as party politics in Trinidad and Tobago. But that problem does not arise in the present case because it was only Justice of Appeal Musai who had the law correct, that he properly took into account the political context. So this is not a case which depends upon questions of fact. It depends upon the Court of Appeal had it wrong in law, and the judge had it wrong in law. So this is not a case, therefore, where the board has to choose between two competing views of the local courts. There's only one judge that expressed views about the politics of Trinidad and Tobago, Justice of Appeal Musai, and the law is that in assessing, in determining whether words are defamatory or not, the court has to take into account the context, and where it is made in questions of politics must take into account the political context. So the decision-making of the High Court judge, which was affirmed by the Court of Appeal, was vitiated by an error of law. And it is in those circumstances the board is in just a good position as the local courts to make its findings on whether the words were defamatory or not in that context, unless I could assist the board further with my submission.
Thank you very much indeed. This appeal has gone well. The board has been lucky enough to be addressed by 3 excellent advocates. The case on both sides has been very well prepared by the attorneys and the London agents. Even the technology has worked well, and we have been able fully to hear and understand what has been said from Trinidad. The board will take time to consider its judgment.